I'd like to get started if we could, please. Somebody asked me at the break if I'm so frightened of powers of attorney, what do I do? And I guess my answer is this: in most cases, unless you're dealing with somebody who is suffering from some kind of dementia, is really incapacitated, the argument is find out where the person who gave the power of attorney is and phone them. People are not incommunicado in most cases, and just check it. I think that would be Reuben Rosenblatt's response, and that may be the safest course of action. Your mom, your dad, they're in Europe, they're traveling. What's their itinerary? I want a phone number. I'm going to leave them a message at their hotel, and so we'll close the deal tomorrow. If it's such a rush, well, then I'm worried about it if it's such a rush, that it can't wait another day or 2 days or 5 days for them to confirm instructions. The next speaker is Paul Broad. He is going to be talking to us. He is a privacy lawyer. Now, you'll say, what has that got to do with real estate? Well, it does have a lot to do with what we do day to day in our businesses. As sole practitioners or in private practice. And he's going to let us know what PIPEDA is all about. If some of you have not yet addressed it in your practices, then maybe this will be the impetus for you to do so. Paul.
Good morning. In about the next 15 minutes, I'm going to try and take you through the effect of the Personal Information Protection and Electronic Documents Act, which is the federal privacy law, and its impact on law practice in Ontario. There is a paper in your materials which talks about this in more detail. The PIPEDA regulates the collection, use, and disclosure of personal information, and what's important to us here is that it's in the course of commercial activities. Now, that's a very broadly defined area, and basically, absent a successful constitutional challenge, it applies to all intra-provincial commercial activities. And I should note that there is actually a constitutional challenge ongoing in Quebec right now, but it's at a very early stage. The generally accepted view at this point is that the federal privacy law, PIPEDA, does apply to the practice of law. And just as a quick aside, in terms of employees, for those of you who have employees, if you're in a law firm, generally, PIPEDA does not apply to employee information of provincially regulated employers. There's some debate as to whether it might apply when you engage third-party service providers. I'm not going to talk about that here. That is discussed in the paper. PIPEDA applies to what's defined as organizations, very broadly defined, can mean associations, partnerships, individuals, and so it's going to capture most forms of law practice, including sole practitioners. Personal information, again, is also extremely broadly defined, and essentially you can think of it as any information that could identify an individual. It does not include business information, business card information, basically telephone numbers, names, titles, and it doesn't include a very limited category of publicly available information, which tends to be simply things like telephone book information, that sort of thing. There are 10 principles that animate PIPEDA. I'm not going to discuss them in any detail, but I'll look at them in 5 broad categories. First is accountability. And organizations are basically held to very high standards of accountability under the statute for any personal information that they collect, use, and disclose. And organizations have to appoint a person who's going to be responsible for compliance with the statute on behalf of the organization, develop internal and external policies relating to their privacy practices, and also develop practices which comply with the statute. All of this information is to be made publicly available, or at least summarized in a public form so that somebody could come to you and say, what are your privacy practices when you deal with personal information. Consent and purposes, this is probably the key area, and we'll discuss it in more detail in a minute or two. You have to identify reasonable purposes whenever you collect, use, or disclose personal information. And the consent has to be informed, and there's very limited, well, some ability to imply consent, and there are some exemptions from the consent requirement, but it's a general consent requirement. Limitations are imposed on how much information you collect, use, and disclose, and basically the rule is it has to be information that's necessary to the purposes that you've identified in the first place. And same with retention, you're only supposed to keep the information to fulfill those purposes, absent, of course, any legal requirements that impose a longer period of time. Accuracy, safeguards, put in place appropriate safeguards to keep the information from getting into other people's hands. There is also access and compliance procedures, and this is a new thing. And PIPEDA basically allows individuals to access their own information, except in limited circumstances, for example, where solicitor-client privilege applies, if it's part of a formal dispute resolution process, confidential commercial information. But otherwise, there is a general right to access, a general right to challenge correctness, to challenge completeness, and then there's a complaint procedure which allows an individual to go to the Federal Privacy Commissioner, who can issue recommendations, and ultimately these can be enforced through the federal court system. So, concerns for lawyers. Well, I think we all would agree that in the course of our practice, we all come into contact with a lot of personal information. And the information can relate to our own clients, it can relate to people who aren't our clients. A lot of it is very highly sensitive, a lot of financial information, for example. And what PIPEDA really does is imposes a level of regulatory regime, a new regulatory regime on all lawyers who are practicing, and requiring an examination of policies and practices. So from an administrative side, law firms are going to have to look at appointing compliance officers, privacy officers, making that person known internally to their employees, to agents that they use, and then also to the public. Develop policies and practices that regulate retention and collection, for example, and developing privacy statements. Some of these could be posted on your website, handed out to clients, but in some way made available to the public if requested. Audit issues. Do you know what personal information you have in your practice? Where do you get it from? That's quite a challenge right up front, is even just trying to figure out what exactly do you even have. Do you know all of your direct and indirect sources of collection, the internet, email? There's all sorts of ways that you can get it. How do you use it? To whom do you disclose it in the course of a given transaction? All of these are types of questions that you need to have an answer to if you're going to be able to develop policies and practices. Agents and employees. As an organization, the law firm or the sole practitioner is responsible for what their employees and their agents do. Law clerks, personal assistants, or there are all sorts of people who work for you and are going to be handling personal information on your behalf. There's going to be an element of training to make sure that they understand the act and what it imposes on them. Oversight mechanisms. How do you make sure that they're complying, since you're at the end of the day going to have to answer for what they're doing. The key area, of course, is really the consent and the whole notion of collection, use, and disclosure. And as I said before, the general rule is an informed consent, which generally means that the individual knows the purposes for the collection of the information, the use to which the information is going to be put, and to whom it's going to be disclosed. Now, it doesn't have to be specific. That can be more general. I have to disclose it to another lawyer. I have to disclose it to the mortgage company, something like that. You can imply consent, and really the question there is it reasonable to do so in the circumstances that I'm facing? This is highly dependent on the sensitivity of the information. The greater the sensitivity, the less likely under the statute that you'll be able to imply a consent. There are some exemptions from consent in the Act. There's very few for collecting information. Again, the general rule is you have to do direct collection. if it's in the interest of the individual and you can't get a consent in a timely fashion, if you're investigating a breach of an agreement or a law and consent would comprise the availability or accuracy of the information, journalistic, artistic, literary purposes, or if it's publicly available. Similar exemptions for use of information. Disclosure is a little bit more helpful. There is a general exemption for disclosure if if an organization is giving the information to their lawyer. So in this case, we would be receiving the information from our clients, and it's not clear in the Act, but I think it's becoming the accepted view that in this situation, the lawyers may then use the information for the purposes that they received it, i.e. to provide the legal services that were in view. So that's quite helpful, actually, when your client is giving you personal information, that you can then use it and disclose it as necessary to provide the services back to them that they've retained you for. You can also disclose information without consent to collect a debt that's owed to you by somebody else, which is also going to be quite helpful in some cases. As required by law is another reason, so if there's a legal requirement to disclose, that's not a problem. In terms of looking first, we'll look at direct collections, because this is where you're going to want to try and build in a consent up front to try and just deal with the issue so you don't have to worry about it later on. And then consider to what extent you want an explicit consent from the individual. Perhaps you might make it as part of your initial retainer with a person. That's maybe an easy way. You might want to set up a separate consent form, modify your existing forms where you're already collecting personal information, and have a generic statement of, we'll need to use and disclose this to third parties in order to process whatever the actual thing that you're dealing with in that circumstance. In some cases, you're going to be able to imply consent. Other ways that I know some companies and law firms are dealing with are putting just all of this into a policy which they're making available to their clients, so the clients then at least have notice of the privacy practices. Indirect collections tend to be more problematic, especially when it's information that relates to non-clients. And how do you ensure in those cases that an appropriate consent is obtained? 5 minutes? Okay, I'll be 2. This could arise, for example, when you're dealing with the purchase of a rental property, and you're dealing with tenant information that's coming across, then there's many possibilities here. In some cases, there may be an exemption applying, not likely in most cases. In others, you may be able to imply consent. One way that people are dealing with it are contractual commitments. Do we get a commitment from the organization that initially collected it that they complied with PIPEDA? This we're beginning to see in our practice from some of our clients who are sending us these agreements to sign off saying that we now comply with PIPEDA. Potentially put in an indemnity clause so that if they violated the Act, we're not going to be the ones who are responsible for any damages that might ultimately be awarded. At the end of the day, the problem is PIPEDA doesn't really give much guidance on any of these issues. It clearly was not drafted with law practices in mind, and some might say with very few business practices in mind either. There is an element of risk management in all of this, and assessing the appropriateness of available exemptions, the reasonableness of applying a consent in a given situation, and frankly, the practicality of obtaining an explicit consent in a lot of cases is just not going to be feasible. And so you then have to figure out how can I best ensure that the Act is being complied with and protect myself and my clients as well. And I will recommend 3 different places you can look. On the Practice Pro website, this is www.practicepro.ca. If you then type /privacypolicy.asp, there is a model privacy policy for law firms that that has been placed there. The Law Society website, if you do a search on their website and type in PIPEDA, you'll be taken the first link to a question and answer document that deals with more detailed issues of the impact of PIPEDA on law practices. And also on the Law Pro website, the September 2003 Law Pro magazine had an article on PIPEDA as well. Okay, thank you.
You know, practicing law is getting harder and harder and harder. It's bad enough that we had to figure out where our clients are going to come from and where our next billing is going to come from, but then we end up with having to learn E-Reg, and then having to figure out title insurance, and then having to deal with PIPEDA, and figure out what we do with that in our practices. And then we got to deal with Brian Bucknall, because he's going to talk to us about another headache of new law. And knowing my friend Brian, as I do, he's going to ask a lot of questions. And hopefully, he's also going to give us a lot of answers, and talk about the Limitations Act, or whatever they call it today, and how it affects real estate. Brian.
Thanks, Sid. As a preliminary, good morning to everybody, but good morning as well to all the people on the Interactive Learning Network. There is not just Toronto. All we see is Toronto. We don't see these other places, but there are 9 other places, I think, around the province who are involved in this. So good morning to all of you people far away. As a preliminary, personal thanks by me to Jeff Lem, who has reversed his position with mine, and our papers are still in the same places in your binders, of course, and so my paper is the very last one, but I really appreciate him accommodating me. I am going to beetle off as soon as I've completed. That is not a reflection on the sense that I don't need to know anything more that's being talked about in this seminar. The most depressing part of days like this is I sit there and I think, well, why didn't I know that? You know, I think I increase exponentially the amount of ignorance I have by coming to these seminars, and it really, you just have to think about that. I think somebody somewhere should be, and perhaps all of us, should be feeling a very great debt of gratitude to the Law Society and to Sid and to the planning people for putting on this really quite exceptional seminar. I've been extremely impressed with the attendance, with the speakers, with the papers, etc. So we should communicate that to the Law Society. I say that with a complete visceral envy. I am very much associated with the Bar Association. I do a lot of Bar Association things, and I wish this was a Bar Association program. Finally, I just have to make a comment about Sid. Sid was talking about what we are as lawyers, and he said we've been turned into insurance agents for title insurance. Insurance agents. He used that phrase twice. Bad phrase. Bad dog. The Law Society of Manitoba, about 2 weeks ago, issued a notice to the profession. And the Law Society's notice to the profession was that lawyers who arrange title insurance are themselves being insurance agents, and they can't do that unless they're registered as insurance agents under the Insurance Act. And the Insurance Council would prevent a lawyer from registering as an insurance agent. The Insurance Council wouldn't. So what the Law Society has done, I infer, is attempt to restrict lawyers from participating in the title insurance process with the intention that title insurance will not become a part of the profession. It's a very interesting thing. Now, that's not the topic of the thing today. The topic is the Limitations Act 2002. And as I'll explain thereafter, there's 2 Limitations Act now, the Limitations Act 2002 and the Real Property Limitations Act. There are a number of sources on the new Limitations Act, and I've mentioned some of them. The Law Society did a program last summer on the Limitations Act. Graham Mew, who wrote the first book on Limitations Act, has written the second edition, and that's out now, Graham Mew, M-E-W. And so if your library can find that, that's a good place to go. Another place to go, and I hesitate to do this, but I will, is an article that I'm publishing in the in the Advocates Quarterly. And it's somewhat larger, it's about a third larger than the paper that I have here, and it's much more explanatory. It has more space, and so I use a lot more examples and that sort of thing. And I think that's going to be more helpful than the existing paper. It just has a little more to it. There's also been a lecture by Ruth Wall of Ogilvy Renault that was presented here in this room last week in a seminar on securities and insolvencies on the Limitations Act. So there's a lot of people getting into this. I have a feeling over the last few months, because the Limitations Act came in 2002, or it came in January 1st this year, that it sort of crept up on some of us, me included. And we weren't watching, and along it came, and then it was there. And that has, if I may say, confused, frightened, made irrational some people who would otherwise have conducted themselves in an appropriate manner. So that is really the topic that I want to deal with today. I have a set of analytical issues on page 3 of my paper, and I'll just go through these. I won't be able to do the whole paper, we just don't have time, but the major points are: how should the Limitations Act and the Real Property Limitations Act be approached by practitioners and judges? Then, second question, does the scheme of the Limitations Act 2002 suggest a new approach with regard to jurisprudence concerning the limitation of civil claims? Then, how does the scheme of the Limitations Act 2002 interact with the Real Property Limitations Act? And finally, and I won't go through all of these, issues with regard to the Limitations Act 2002, the non-real estate side of things, concerning commercial transactions. Now that's possibly not something we as real estate lawyers are always doing, but I swear to you it's going to come up, and you're going to be dealing with colleagues and people on the other side, and you want to know the decisions. In approaching the new legislation, I want to start with a footnote, and the footnote deals with not the Limitations Act, but the Planning Act statements. And there are people here who will remember the introduction of the Planning Act statements in 1984. So we were told in 1984 that if you got the vendor to sign his statement, the vendor's lawyer to sign his or her statement, and the purchaser's lawyer to say it's all kosher, then everything was fine, and any inconsistency with the Planning Act that preceded those statements was wiped away. You washed your hands of it. I remember when that came in, and the degree of concern in the profession at that time was very high, and people said, well, what if the statement is wrong? Or indeed, what if the statement is fraudulent? Or indeed, what reliance can we put on using these statements? These were active questions. Do I go back behind a statement? I've got a deed with a statement in it. Do I go back behind that for contraventions? On and on and on. There were people who said, I've never signed such a statement. I've never been called upon to sign such a statement. I will not sign such a statement. I will not ask for such a statement. I will not rely on such a statement. A group of lawyers in Toronto, a bunch of colleagues from several firms, got together. We sat down for lunch. We sat down for lunch again. We sat down for lunch a third time, and we settled what we said were the principles. We said, we've looked at the statute. It works. We've decided what our practice is. We will sign the statements. We've decided what we will ask for others. We will ask them to sign the statements. It's all going to work. And that consensus became the consensus in the profession, became the consensus that rules today, I swear. There may be some exceptions, but if you feel that you should sign, that the statements are capable of being signed, they are true, you sign them. And in that period, and I think Sid may correct me, but I do not believe the court has ever intervened and said anything about the Planning Act statements, one way or the other. The court didn't need to come. The profession made its decision. I would like to see the profession making its decision with regard to the Limitations Act and the new legislation. I think we have that power if we can create a consensus, and if we create a consensus, We will guide the court instead of waiting for the court to guide us. Now, how do we create a consensus? Because there are ambiguities in the legislation. You look at the principles of legislative interpretation. There are books on this. Some of the best legislative interpretative materials is done by Drijker, a Canadian scholar, worked in Ottawa. And he has a whole book on it, recently re-edited. The basic principles are you look at the context of the legislation, you look at interpretations which avoid absurdity, repugnance, inconsistency. You look at the legislation and avoid any interpretation which creates an absurd consequence. And you look at the legislation and you avoid any interpretation which creates what would appear to be an unintended consequence. So keep those things in mind. That's what the courts will be told if there's a fight over an ambiguity in this legislation. They will say, look for this type of interpretation. Now, let's think about the new legislation, the Limitations Act 2002, and you're probably familiar with this. Limitations Act, as it stood before, had three parts. Part 1, which was roughly the real estate part. Part 2, trusts. Part 3, which was civil claims. Part 1, with a couple sections taken from elsewhere in the Act, remains exactly the same. The words are all there. So if you remember anything about possessory title or prescriptive title, etc., you still know what the law is. Parts 2 and 3 have been replaced by the new legislation. And the new legislation has some elements which are extremely important to keep in mind. First of all, we've moved in the new legislation, not the real estate legislation, in the new legislation to a 2-year limitation period. 2 years, that's the basic limitation period. The 2 years runs from discoverability, but I'll talk about that later. Then there's an ultimate limitation period of 15 years. 15 years after the bad event occurs, it's all done, don't bother us, okay? 15 years, that's the ultimate limitation period. Secondly, we've moved to the concept of a claim, not a cause of action. And that is fundamental. A claim is defined in Section 1 of the Act, and a claim means a claim to a remedy or injury, a claim to remedy an injury, loss, or damage that has occurred as a result of an act or omission. So 2 elements right in the definition. Injury, loss, or damage, that's the person who wants to make a claim. Act or omission, that's what the defendant is accused of. Injury, loss, or damage, act or omission. Now, I'm going to go into this a little later, but this is the new concept that replaces from the earlier legislation the concept of cause of action. The claim, the 2-year period, runs from the discovery of the claim. Discovery. So something has happened. I know now that something has happened to me. I've got 2 years to make it, to bring it to the attention of the party who's responsible. Now, discovery is also qualified by the concept of discoverability. So you're not allowed to be intentionally ignorant of things. If there's something happened and it is something that you should have discovered, the claim will run from the time you should have discovered it. There's another part of the legislation which I talk about, which is Section 5, Sub 2, which creates a presumption of knowledge of a default from the date of the default. Now, I think that is, if you'll excuse me, horseshit, but I'll write it out for you. And I explain my thinking on this. I mean, it really is a very odd section, but that presumption of knowledge will have to be dealt with. Finally, there is a Section 22 which says you cannot contract out of the limitation period. You cannot contract out of 2 years and make it 1 year. You cannot contract out of 2 years and make it 5 years. It's 2 years. It's 15 years. Don't try and change that. Now, those principles are really important. They're seminal in the whole process, and we have to deal with them. I want to get to the meat of this right now for real estate practitioners, and that's the Real Property Limitations Act and the intersection between the Real Property Limitations Act and the Limitations Act 2002, because they do intersect. I have colleagues, you have colleagues, I say with some regret I have partners, who think that because real estate is real estate and everything else is everything else, we do not need to worry because we have our own Limitations Act. Disabuse yourself of that notion, disabuse your partners, your colleagues of that notion. It just isn't the case. We really have to know both acts and apply both acts. Now, the real property limitations are definitive where they exist. They're definitive where they exist. So if you have someone in possession of a piece of property sitting beside of your property, someone's in possession, you don't have 2 years to get them out, you have 10 years. 10 years is the classic time. If you have someone who is using property, as was discussed yesterday by Leor Margulies, to travel on, that's a prescriptive easement. What are the limitations period for prescriptive easements? 20 years and 40 years. And I won't bother explaining the difference between them, but that is what it always has been. That is what it is now. I am going to just make one more footnote here, and that's with regard to the discussion of the moving of a piece of property into land titles qualified, and whether, to use Leor's phrase from yesterday, that stops the clock on any period running. I personally agree with the analysis that Rosemary Grenside used, and why wouldn't I? I taught it to her. I disagree with Leor, and I disagree with Kate Murray. It seems to me that an estate, a possessory estate or a prescriptive estate, exists from the date possession begins. It doesn't exist, and Leor is referring to some jurisprudence that says the estate is finished when the 10 years is, the estate is established when the 10 years is done. That's not the law, that's not the common law, that's not the statute. 10 years, you go into possession, you have an estate right then, it continues until you're dispossessed of it, or 10 years has passed. When 10 years has passed, you don't have any different estate than you had at the beginning. What happens is that the legal estate is extinguished. And that's a very important point. So, and I've published on that a couple times already, so we can have fights on that. The other things, I told you about prescriptive easements, mortgages, there's still that provision in the Act that a mortgage expires and the estate, which is the mortgage estate, expires 10 years after the last payment. So that's it. Is that the whole story with regard to real estate? Probably not. I'll give you this example. A lease. Lease is an estate in land, right? Okay. Let's have a 10-year lease. Tenant is responsible for repair and is responsible for structural repair. Argue that that's unusual, but let me use the hypothetical. Landlord comes along in the 6th year and sees that the roof is leaking, okay? So the tenant has breached the covenant for repair. What is the landlord's right at that point? Well, the landlord might move to terminate for breach of covenant, fair enough. The landlord might move to make the tenant perform the covenant and repair the roof. The landlord might just lie back and wait. But after 2 years, in the 8th year, is there an obligation between landlord and tenant with regard to the repair of the roof? Possibly not. Possibly not. Possibly you cannot enforce that covenant later on. Question, if you can't enforce the covenant, could you still terminate? Interesting issue. Can I terminate for an obligation that the tenant is no longer obliged to discharge? That's going to be in the courts in some point. Same issue with regard to mortgages. You know, you might have a mortgage with a covenant for repair, for the mortgagee to repair, and that the disrepair might occur. Can you exercise that any time during the mortgage? Questionable. When any of you or any of your clients sees a state of covenant that's in breach, the time to act is now, not later. A couple of issues are arising, and this is the area where there's a lot of controversy in the bar, and that's with regard to commercial transactions. And this is where I think some degree of irrationality may have crept into our practices, particularly with regard to representations and warranties. If you know an asset purchase, you will know that it's always decorated with all sorts of representations and warranties. Now, question, can a representation and warranty last for more than 2 years? Can I have a representation for 5 years? If I have a representation for 5 years, have I extended the provisions of the Limitations Act contrary to Section 22? Is that cut off? Now, I have friends who say, yes, it is cut off. And this is particularly with regard to Section 22 and Section 5.2. You're presumed to know that something has gone wrong. My position is that a representation and warranty is simply another type of contract. Okay? You could have the asset agreement with no representations and warranties at all. That's a perfectly valid contract. You could have it with 6 pages of representations and warranties. That's just another form of contract. If I can have a 5-year lease of a car, I can have a 5-year warranty. What happens within the representation and warranty system is that when you realize that the warranty has been breached, then you have 2 years. So imagine you have a representation and warranty which is intended to last for 5 years. Your purchaser discovers in the 2nd year that in fact something has gone wrong. I think the purchaser has 2 years in which to bring the action. If the purchaser decides not to bring the action, that action is gone in the 4th year, not the 5th year. So that's the position I take. There are people who take the opposite, take another position and say, no, we're really uncertain about this. We will see the representation warranty as actually not capable of lasting more than 2 years, and therefore we're going to create a system, a contractual system of indemnities. So instead of saying, I represent and warrant that this property is structurally sound, the contract would say, I will indemnify you at any time within 5 years if you demonstrate that the property is not structurally sound. I don't think there's anything wrong with using the indemnity process or the representation and warranty process. They come to the same result, but I wouldn't spend a lot of time in controversy over it. A second point that is really interesting is with regard to demand debt. Again, a bit outside of our practices, but it'll come up. A demand debt would be a promissory note. I promise to pay you $10,000 on demand. You give me $10,000. So I've got the money, you've got the promissory note. Does the promissory note last for indefinitely, or does it last? Is it extinguished in 2 years? Well, there's a whole bunch of old jurisprudence under the other act and under acts in other jurisdictions, which says that the cause of action where demand debt occurs arises when the debt is given. So when I've given you a demand promissory note, you have a cause of action against me from and after, after that date, and that cause of action will last for 6 years. That's jurisprudence. That's jurisprudence in Ontario. That's jurisprudence in other provinces. Question, does cause of action and jurisprudence with regard to cause of action rule with regard to claims? We've got a definition of claim that is new. We would have to convince a court that when I gave you a promissory note for $10,000, I was causing injury, loss, or damage to you by giving a promissory note, and my action in doing that was an act or omission. The very definition of absurdity, I think, has been established here. And now, people who are less confident of this than I am do say, well, I'm going to tell all my clients, if you're going to have demand debt of any sort, and that includes book entries and that sort of thing, if you're going to have demand debt of any sort, make sure that you refresh it with an acknowledgement within the 2-year period that it's created. So there's a whole system of acknowledgements which can make it work. There is a lot more to say, but there isn't a lot more time. So there's Limitations Act.
You know, I felt a little guilty when I used the word pissed off in my presentation, but now I've got something on. Now I'm going to tell you what you can do from now on. In order to have your outrage have more credibility, you can now say, to quote Brian Bucknall, this is horseshit, as opposed to just saying this is horseshit. Thank you, Brian. Reuben Rosenblatt really doesn't need an introduction, but I'm going to give him one. He is passionate about the law. There is nobody I know who, when you start to talk about a case, doesn't immediately start talking about 10 other cases and start to go into high gear, so to speak, to the point where you almost need to tackle him to say stop already, because his passion and his love for the law, for the courts, for the decisions, for legal thinking is so strong. Reuben is going to take us up to about 5 minutes after 12, if I can give him his full 25 minutes to talk about good faith. You're also going to see Reuben this afternoon in what I call the fishbowl, our last panel discussion. It's going to be more than that. I really do hope that you will be around for the whole of the afternoon. It will be most interesting. Reuben.
I have to admit that I have been coming to these lectures either as an attendee or giving these lectures, and I was absolutely amazed to hear Sid twice saying pissed off, and Brian with his bow tie saying horseshit. And then Brian talks about the quality of speakers, how impressed he was, and then before I get up here, he leaves. And Sid's right, I do tend to get passionate about the law. It's my love and it's my hobby. Although I am like Sid, where I do get up at night, like last night, you don't want to stick to your written material, and you think about what you want to say, you think about your family, you think about the kids. The only difference between Sid and me, he thinks about his dog, I think about my 3 sick cats. As Brian speaks and as Sid speaks and other people speak, I do always want to make a couple of comments. Another personal experience, I do want to make at least one. And if I get through, I'd like to speak about power of attorneys, that 5 lawyers were going to give expert evidence on the duty of a lawyer with respect to a power of attorney. And the case actually, what happened is I had given evidence. It was a case where Premier Trust was suing, and it was suing a lawyer about giving a power of attorney. And what happened, it came out that Premier Trust had assigned the mortgage to its company, National Trust, and the lawyer had started the action with the wrong plaintiff. So that's another big concern about lawyers in litigation. Anyhow, I'm going to go one comment about leasing. Sid mentioned about leasing and lawyers being sued. One of the first claims that was going to come against me when I was a young lawyer is I acted for a tenant. Tenant was moving into a restaurant, spent hundreds of thousands, or at least $10, spent a lot of money on because I didn't have clients that could spend $100,000, spent a lot of money on fixing up a restaurant. got a very low rental because he put in so much money. And after the tenant had been in operation for 6 months, we got a notice from the mortgagee demanding a possession of the property. And I had no idea what the mortgagee was talking about because I didn't know anything about a non-disturbance provision. So that has always been a fright to me, a scare to me. So since Sid mentioned leasing, when you're acting for a tenant that is moving into a property and you have a limited retainer, find out if there's any prior mortgages that could come along, and if you got a low lease that could suddenly come and kick you out. So because this was so personal to me, non-disturbance clause is really important. I act for mortgagees now, and there are so many times where we take possession of a property, see a tenant where it's paying less than market rental, and we'll take a position to try and get vacant possession. So I hope you don't mind if I added that. Good faith. In the last 20 years, there have been so many articles, so many judges talking about good faith. Last number of years, many academic articles. And I remember, and I've been interested in the topic, we spent a lot of time when there was a master's course in it talking about good faith. But I've never been able to get out of my mind what Mr. Justice Grange, as he then was, in 1985, dealing with a topic called good faith in commercial transactions. And I quoted him in the article, and he said, "What is good faith? What is reasonable or unconscionable? I can answer that quite simply. Give me the facts, and I'll tell you." Well, 20 years later, and all the articles later, I ended up my article with the same thing, because I don't think very much has changed. The Supreme Court of Canada, in a case called Martel, and the cites will be in the article, said that there is no duty or no obligation to negotiate in good faith in the pre-contractual stage. So when you're negotiating a transaction, the Supreme Court said there is no obligation to negotiate in good faith. And it held open the question as to whether there is an obligation to act in good faith in the performance of a contract. It made that distinction. So when performing a contract, is there an obligation? And very recently, in 2003, in a motions court where they were pleading it, they were pleading as an independent cause of action, the trial judge confirmed that there is no independent obligation to act in good faith separate from the contract itself. So to me, I want to address my marks primarily to the real estate bar and to what we as lawyers have to do in a very practical situation. So first of all, the obligation to disclose. We have a doctrine of caveat emptor. The Supreme Court of Canada, in a decision, Fraser-Reed, not referred to in my notes, said, you know, the doctrine of caveat emptor really doesn't apply so much in sale of goods, but it's lost none of its pristine force in real estate. So we have the obligation, no obligation to negotiate in good faith. We talk about caveat emptor, and caveat emptor means let the buyer beware, and it means absent fraud, a purchaser takes the property as he or she finds it. So is there a duty on a vendor to disclose? Well, there was a case in 1979, to me, the leading case on this, called McGrath. In this particular case, what happened is there was actually a landslide from adjoining property that came down on a purchaser's home that he had just bought. It was out in Scarborough. Scarborough ordered the person to move out. He couldn't live in his house for 2 years. He had given back a mortgage. The mortgagee brought an action for possession and the purchaser, who couldn't afford to make the payments because they were paying rent somewhere else, said, hey, there was an obligation to disclose this latent defect. In that case, the court found as a finding of fact the vendor didn't know it was dangerous, therefore the purchaser was stuck with the property, caveat emptor applied. But Mr. Justice Dubbin said, well, I'm going to make a change. I'm going to now say that there is an obligation. Now, he didn't use the words good faith, but to me, this is a good faith obligation. What he said is, if the vendor knows that the premises are uninhabitable, dangerous, or likely to be dangerous, then there is an obligation to disclose. Well, that's a little different than what the Supreme Court of Canada said, no obligation to disclose or to bargain in good faith. So as real estate lawyers, when a client comes to you and they say the furnace is not working or the roof is leaking or the basement, do I have to disclose that to a purchaser? You have to think, is it dangerous? Is it uninhabitable? Will it make even part of the premises, if it's a leak in the basement, that you can't use the basement? Recent case said that makes it uninhabitable. So the point of the matter is there are certain obligations to disclose. If you have a client that comes to you, whether it's a commercial property or residential property, said, got to sell my property, I think it's contaminated. You want to sell it as is. Is there an obligation to disclose? If it's dangerous or likely to be dangerous, my answer would be yes. Case came out dealing with that as well. Some Ryerson students were going up to a subdivision also in Scarborough, and they were doing a test for Ryerson schools, and they found that the whole subdivision had been built on during the war on an area that was contaminated. Well, in this case, a vendor was selling a property, did not know that there was contamination on the soil, but had found out that was contamination in the area. When this came to court, the court had to deal with, was there an obligation to disclose something that was contaminated in the area, not in the on the property, that may be dangerous? And again, the court said, yes, there is an obligation to disclose. In my opinion, if it's dangerous, likely to be dangerous, or uninhabitable, there's an obligation to disclose. To me, that's a good faith obligation to get a result that the court thinks is fair. If you know in a court of appeal decision, vendor of a commercial property was selling a property to a purchaser that he knew wanted to build a subdivision. The vendor had gotten an appraisal. The appraisal said that the lands were being downzoned. The vendor did not disclose. Court said there was no obligation to disclose. Purchaser was sophisticated, had lawyers, could have covered himself by provisions in the agreement. So there you have to make a distinction. What about sole discretion? What are the things that we as lawyers see all the time? Sole and arbitrary discretion. What does that really mean? Again, I want to refer to a case called Marshall and Bernard Place. And this is a case, I have to say, surprised me when it came out, and I wasn't surprised when it went to the Court of Appeal. This was a case where it's a purchase for a home for $1,500,000. It was subject to a building inspection report, which we've all seen, sole and arbitrary discretion. The builder got the inspection report, and the inspection report showed repairs that maybe would be required of a couple of $1,000, $2,000, $3,000. When you read, if you read, and I don't think I included it here, if you read the amount of the building inspector's reports, could be a potential problem with the roof in 10 years. The items were $500, $1,000, and the purchaser said, I don't want to close. And so it came to court, and there was, I think, a $150,000 deposit here. And it came to court, and the argument the vendor said that you have to exercise your discretion reasonably and in good faith. And the purchaser said, yes, I am. I imagine the purchaser happened to be a New York resident. They were going to want to fix up the place, or they were going to rent it out. Court said this might have cost them in time. Who knows what type of trade you could get? And the court said the test isn't how small or how trivial it is was the discretion exercised reasonably and in good faith. And that was a test in good faith. Court made a finding of fact. It was exercised in good faith, went to the Court of Appeal. Court of Appeal agreed. That was the test. If the purchaser, by the way, if you ever have one of these sole and arbitrary discretions, you also, the test is, it came from a case called Greenberg and Moffitt, you have to take steps. You can't just suddenly say if it's subject to a soil test or the purchaser being satisfied that the soil is capable of building a house. Purchaser can't come along and just say, I'm not satisfied. You have to have something objective as well to prove that you're exercising it reasonably and in good faith. When we talk about implied obligations, again, we say this agreement is conditional of the purchaser arranging financing. In one case, purchaser went to the bank. Purchaser actually did not realize that interest rates had gone up. Found out that interest rates were gone up, said he did not want the property, called up the vendor, said no way. Court said didn't exercise it improperly, went to the Nova Scotia Court of Appeal. Nova Scotia Court of Appeal said, and we've adopted this in Ontario, you have to make application to see if you could get financing. It's not enough to say I don't like the financing. So same thing with Committee of Adjustments, or a SID with UC, offers conditional upon getting Planning Act or Committee of Adjustment severance. You cannot just say, well, I questioned a member of the panel, and I don't think I will get it. You have to make application in good faith to see if you could have that obligation satisfied. In a recent case, I think it was in 2002, and this is where we keep making mistakes about this, and this is what I'm saying is that you have to avoid being somebody that Sid's going to look after you, or Rosemary back there. You have to take your steps. In a recent case, 2002, it was a sophisticated purchaser, and he had a clause in there that it was due diligence at his discretion. And he just said, I don't want to. He asked for an extension of the condition. The vendor said, give me an additional deposit, non-returnable. The purchaser said, no way, I exercise my discretion. I don't want it. And on discoveries, they asked him, they said, well, what do you think that meant? He says, it means whatever I think it means. And the court says, no, it doesn't. And the court actually tried, in a way, the lawyer at the court realized that they had to make efforts. And Mr. Justice Pitts says, I cannot accept purchasers' counsel's, and this is the quotes, valiant attempts to get on the record some attempts made by his client to secure financing in obvious recognition of the need for good faith in the performance of contract. The litigation stage is too late for the lawyer to say he made efforts. It's up to you, when you have a conditional clause, to see that your client does take the steps to see if that condition can be satisfied. If the purchaser would have gone out and did some feasibility studies, if he would have gone up to actually try to get financing and he couldn't, or made some efforts, then it becomes good faith. But you can't sit down, just simply say, I exercise my discretion and I don't want it. So there, to me, is we have good faith in an obligation to disclose, we have good faith in a discretion, and we have good faith in an implied obligation. What about requisitions? What about requisitions? I started teaching at Osgoode Hall 27 years ago. When I first started teaching, the case laws said that a requisition is valid or not valid, and the motive doesn't matter. That was 27 years ago. The last number of years, the court said, yes, motive matters. When I was a young lawyer, if you made a requisition with respect to an encroachment or with respect to an easement, and you wanted to get a client out of a transaction, if you had an easement there, an encroachment, you could almost invariably get the purchaser out of the transaction. But now if you make a requisition with respect to an easement, the court will say, does it affect the use and enjoyment of the property? And in determining whether it affects the use and enjoyment of the property, the court says, let's look into the motive. Is there just saying that they affect use and enjoyment? Are they saying, yes, this easement prevents me from building a flower bed or putting on trees? Or is the purchaser really looking to get out of the transaction? So now we have cases where the courts say, we're going to take a look. Has the price gone down? So in interpreting whether the requisition is valid or not, the court may, as one factor alone, look at motive. I'm not saying that if you're retained to get a purchase out of a transaction and you have a valid requisition, you still may be able to get that purchaser out no matter what the motive is. But in certain cases, like easements, like encroachments, the court will look at motive. And little things that we used to be able to get clients out, the courts are not looking at anymore. They're looking at good faith. So that's what's happening in the real estate market. But what about requisitions? In one case, and this is a case that I've always had a little bit of difficulty with as a lawyer's function. And this is the good faith in getting a client out of a transaction. Courts are saying, in a case, leading case called Missouri, Mr. Justice Grange, who's the one whose quote I just read, he is the one in a case where there was a very, very small piece of land where requisition was made with respect to a small piece of land. Purchaser wanted to get out. It was a market that had gone down. And it's interesting, in that case, the trial judge said the purchaser was successful. Went to the Court of Appeal, and Mr. Justice Grange was sitting in the Court of Appeal. And he said, vendors and purchaser owe a duty to each other to honestly perform a contract honestly made. The policy of the court ought to be in favor of the enforcement of honest bargains. Well, what happens with requisitions? What happens when a client wants to get out of the transaction? Do we look at this quote, or do we say we have a right to get that purchaser out of the transaction? And that's a difficult question even now in a case where a lawyer was retained, where a mortgage company did not want to make advances because they would have lost millions if they would have made advances. Lawyers submitted about 50 requisitions. The trial court said these requisitions were not made in good faith. Lawyers should not be submitting requisitions that he doesn't think are valid requisitions. The Court of Appeal said, we're not going to deal with that. The requisitions were validly answered. So we see that even in requisitions, we now have to start turning our minds to a good faith. That means I can't talk about power of attorney. Okay, just about answers. I don't want to just deal with answers of requisitions. In your agreements, it says when for a vendor, unable or unwilling. Unable or unwilling. Well, one of the leading cases was a number of years ago, Supreme Court of Canada. Purchaser made some requisitions. This time the land had gone up in value. Vendor didn't want to close the transaction, so the vendor said, I'm unable and unwilling. And again, the court said no. Even then, this goes back a number of years, you can't just capriciously or arbitrarily refuse to answer requisitions. You have to act in good faith. I want to caution you as lawyers, myself, and Sid with standard forms. In a lot of law firms, in the boilerplate, you see in your Newsom and Gilbert or Dye and Durham or whatever the printed forms, unable or unwilling. That's how we grew up. In standard forms, they're taking out the word unwilling, and so it says only unable. There is a difference. Be careful if you're acting on that. Two more comments. The exculpatory provision. Oh, before I get to that, this is more important because I get called on this fairly often by lawyers. I've taught a lot of students. I give them an open line to give me a call at any time. Sometimes they'll give me a call. Every so often a student will say, I have a good requisition, and they think that it might be a good idea to wait until it gets closer to a closing date to submit that requisition so the vendor won't have time to answer it. That is not only not a good faith thing, it's not something to do. The courts have condemned that practice. They've called it sharp practice. They've called it lying in the weeds. So be careful about that. Make your requisitions on time. If you see it on your title search, and even if you know, you have to live according to our own standards and our own profession. And so whether or not it may help the client, you requisition that in the appropriate time. Mr. Justice Laskin, before, and I'm talking about the Supreme Court, Judge Laskin, his son now sits in a court of appeal, when he was a professor, one day said, fraud is an elastic concept. As a lawyer, I never knew what he meant by that. I didn't know what that meant. When I started teaching and I started thinking about it and I started looking at the cases, and I looked at the dictionary, I thought he meant an elastic band, you see. But what he really meant, in my opinion, is it stretches, it moves, it expands, depending on the circumstances. If a judge thinks you're a bad guy, they're going to find fraud. If they think you're a good guy, they might say there was no fraud. And to me, what has happened after all these articles, I think good faith is the opposite of fraud, but yet the judges will look and say it's an elastic concept. It expands, it moves, and it fits the circumstances that you're involved in. To me, trials are a difference between the good guys and the bad guys. To me, you act in good faith, and you would be successful.
Thank you, Reuben. We're going to convene again at 1:30. There is a handout. I'm going to hold it against Jeffrey Lem from Now Till Forever that he had to change something in his paper because there was a mistake in it. So if you haven't gotten a replacement page, please get those outside as well. We'll see you back here at 1:30. Thank you.